There's a phrase by Napoleon Bonaparte that says, "A man will fight harder for his interests than he would for his rights." I want you to know that everything within this appeals case really has a lot to do with the private interest, monetary interest of certain people against the other monetary and private interests of another people who control an entity. And your right is right in between both of those interests. They are fighting for their interests. Are you going to fight for your rights? The good part is you don't even have to fight. Just step outside from that middle spot where your right is and let them clash. The conclusion of that battle is what you will use to your benefit if you're still functioning within a specific sector, whether it's private sector or public sector. But if you're still an employee, just step away from the middle and use their words against each other. In summary, what we're going to talk about is regarding jabs, face masks, and weekly tests by OSHA for people who are still somehow working, and how you can put it to use. But first, let's just go over the basics of what it is before we start talking about whether you can put it to use or not. The word lockdown. Lockdown is a terminology that's usually used in jails and prisons, whereby certain inmates get punished. I don't think it has crossed a lot of people's mind that with what's going on with the so-called pandemic and the so-called lockdown that's going on that has happened, people don't quite realize that they're not as free as they think. Although the other parties, on the other hand, are telling you, look, you are not free. And we are exercising that power over you so you know that you are not free. They go as far as to call whatever it is that they're doing on their end as a lockdown. They use a terminology that applies to people who are confined in a very limited space, such as prisons and jails. Here we are, we have billions of people on earth who accepted and truly believes in this concept of lockdown. But if you ask them, are they free? They'll say yeah, because in their mind, they're not inside some building called a jail or prison, but they are on lockdown. Their lifestyles have changed. There's a West African proverb that says, where you stand during your youth shows where you sit during your old age. Meaning what you do while you are young, and what you stand for while you are young, shows the level of comfort and position of comfort where you will be. And even worse, if you are not careful, regardless of whether you're standing or sitting down comfortably during your old age, what type of future have you left for your children? It's the question you ought to be asking yourself with what's going on right now. Because if you aren't doing anything right now, and you have children, or you're planning to have children, or you just never know what the circus of life and the ebbs and flows might place you, just ask yourself, what type of world do you want to leave for the younger generations with what is going on? Your individual activities makes the difference when it comes to the total circumstance. And information is basically the water to a plant. Your mind is the plant. Information is the water. Information is the sun, the light. So let's shed a little bit more light to what is going on right now. There are people out there that still have to be an employer, an employee, and be employed by others who give them certain conditions and ultimatums that if you don't do one thing or the other, the integrity of your job security is basically jeopardized, regardless of whether it's private practice or not. If you are an employee, there's an appeals case that basically says, and by the way, OSHA is the practice of safety when it comes to health or anything that could be hazardous to the well-being of the employee. More specifically, people within the healthcare field. And if you're not, OSHA rule often still applies. And here's a Supreme Court case as of last month, November 12, 2021. The United States Courts of Appeal, Fifth Circuit, regarding mandates of OSHA under the presumption of safety and whatever it is that they're saying that employees have to align themselves with when it comes to this whole pandemic and whatnot. The appeal case number is 21-60845. What does it say? By the way, the plaintiffs are some small business, some other types of business, a few municipalities, some other corporations, some restaurants in different states. And some states themselves are part of the suit. The state of Louisiana. And the one whom the petition is brought against? OSHA, Occupational Safety and Health Administration. The people who regulate the laborers, United States Department of Labor, the Secretary of the Department of Labor, and the Secretary of OSHA. So let's read what all these are saying. The Occupational Safety and Health Administration reasonably determined in June 2020 that an emergency temporary standard, ETS, was not necessary to protect working people from occupational exposure to infectious disease, including the C word. That extraordinary power is delivered to OSHA under the emergency provisions of the Occupational Safety and Health Act. That power should be delicately exercised, and only in those emergency situations which requires it. This case concerns OSHA's most recent ETS. ETS being the Emergency Temporary Standard. Then we're going to change the standard of how things operate based on the safety and health of the people who are employed and provide labor. If you're an employee, this applies to you. We're going to change it. We're going to change those standards because of an emergency. That's what we're talking about. And that's what the case is concerned about. The agency's November 5, 2021 Emergency Temporary Standard, aka the mandate. Now there's a mandate on the state level, and then at a later date they issue the federal one. Then every now and then all these other sub entities like train stations and whatnot, each municipalities adopted theirs also. Of course, the agency called OSHA, which deals with safety and health administration of employees within people who enter into contract with subsidiaries of the United States, which is majority of the people. This entity created a mandate synonymous with that, which requires employees of covered employers to undergo the C word jab or vax, or take weekly C word tests and wear a mask. Usually the reference here in the little asterisk at the bottom. Here's a reference for your record. An array of petitioners seek a stay barring OSHA from enforcing the mandate. What is the mandate? Just so we're clear, what is being disputed here? The mandate is that employees of covered employers, meaning whoever falls under the OSHA's jurisdiction, which is 9 out of 10 entities, even the ones that you think wouldn't apply, they all fall under OSHA regulation. Their employees, their workers, must undergo the C-19 jab, meaning they must take the jab. And then, or in place of taking the jab, they have to take the test and wear masks. An array of petitioners seek a stay barring OSHA from enforcing the mandate during the pendency of judicial review. Judicial review is a formal term of how some type of judicial power, whether the internal or external, reviews some type of agency's decision or rules and regulation before making a final and permanent. On November 6, 2021, we, meaning the appeal court of the United States, which OSHA is an agency of, and they even tell you the agency, we, the appeals court of the United States, agreed to stay the mandate pending, and it's still ongoing as of the date of release of this document, which was November 12, 2021. We agreed to stay the mandate pending briefing and expedited judicial review. Having conducted that expedited review, we reaffirm our initial stay, meaning they concluded their initial decision. The legal word to stay something is to basically stop it, to bar it, to pull a wall in front of it, to stop it basically. OSHA promulgates its much anticipated vax mandate on November 5, 2021, framed as an ETS, an emergency. The mandate requires all employers of 100 or more employees to develop, implement, and enforce a mandatory C-19 vax policy. Meaning now it is part of every employer's terms and conditions of employment. Connect everything and see how everything connects. And that terms and condition of employment is being compelled upon employers by the guys who supposedly regulate the health and safety of employers. And it requires any worker who remain unvaxxed to, quote, undergo weekly C-19 testing and wear a face covering at work in lieu of vaccination. Meaning if you don't get some type of poison in your system, you now have to be subject, based on your condition of employment, to weekly get stuff stuck on your nose, into your nose, close to the membrane of your brain. And you have to suffocate yourself indoors, which builds more germs, basically make your body a host for disease. On the afternoon of mandate's publication, a diverse group of petitioners, including covering employers, states, religious groups, and individual citizens, moved to stay and permanently enjoin the mandate in federal courts of appeal across the nation. Why is this not in the news? Finding, quote, cause to believe there are grave statutory and constitutional issues with the mandate. We intervened and imposed a temporary stay on OSHA's enforcement of the mandate for ease of judicial review, and in light of the pressing need to act immediately, we consolidated our court's petitions under this case number captioned above. And if you go into this case, you will find a conglomerate of the preceding paperwork that they're making reference to here. Many of the petitioners are covered private employers, in the private sector. And OSHA does apply to some private sector. Within the geographical boundaries of this circuit, their standing to sue is obvious. And mandate, meaning the issues of territorial and personal jurisdiction. The mandate imposes a financial burden upon them by deputizing their participation in OSHA's regulatory scheme. exposes them to severe financial risk if they refuse to fail to comply. Meaning this is how they threaten businesses, small businesses and private businesses. They hit them with fines. This is why they're always acting like they're out of their minds, like you're doing something wrong, because it hits them in the pocket. So don't get it twisted. This is still all about commerce. The only reason why they are suing OSHA is because it's digging into their pockets. You, the average man or woman, they don't really care about what you got going on. They care about their pockets. And threatens to decimate their workforces. I mean, our slaves are going to be affected. We're not going to have a good workforce anymore. These people working in the private sector, they're working in the private sector for a good reason. They can go somewhere else privately and get some things done without needing us. You're affecting us, and then you want to fine us? No, we're not standing for that. And business prospects, by forcing unwilling employees to take their shots, take their tests, or hit the road. This is the issue, specific to private employers. Let's keep reading. The petitioners seek a stay, and ultimately permanent injunction, and equitable relief. Equity is where solution is with things of this nature. And you better know that most of these entities out here are putting it to use. The petitioner seek a stay of the mandate's enforcement pending full judicial review of the mandate. We address their request for a stay today. The traditional stay factor governs the request for a stay pending judicial review. Under the traditional stay standard, a court considers 4 factors. Whether the stay applicant has made a strong showing that he is likely to succeed on the merits. Then is there evidence as to why you're saying that we should stop this mandate? Is it worth considering? Whatever you're saying is causing you to demand a stay. Why? And where's the evidence? And 2, whether the applicant will be irreparably injured absent a stay. Meaning, even if we deny that stay, will that cause injury to you, the petitioner, one way or the other? Is it going to cause an undue burden? Whether issuance of the stay will substantially injure the other parties interested in the proceedings. Meaning, just not you, but there are others. And where the public interest lies. So regardless of whether the public sector is bringing this claim or not, or the private sector is bringing this claim, what about the public interest? Is what you're saying you don't want to do, is it having some type of 6 degrees of separation with everyone else? Because OSHA interfaces with both public sector and private sector. So those are the 4 standards that they use to determine whether they want to put a hold on to that mandate, that either take their shots, take their test, or hit the road. Keep in mind, the qualifying term is here is their shots, their tests. Who is there? OSHA. Because the CDC that everyone talks about, that you hear in the news, believe it or not, don't have any power to enforce anything over anyone. They simply don't. They simply give you notice that, okay, this is what we think is happening, this is what we think have happened, or this is what we think is about to happen. And that's about it. It's like a bulletin board. They put stuff on bulletin board, that's it. Now, what's put on that bulletin board cannot mandate you or anyone, nor does it serve as some type of warrant for some type of action. It's just saying this is what we think, and that's it. Now, there are agencies specific to certain avenues of life that can take that bulletin board and enforce it. One of them is the agency of the United States called OSHA, which regulates the safety and hazards of employees who contract with the United States as their employee, one way or the other. So it is their shots, their tests. or hit the road. Moving on. We first consider whether the petitioner's challenges to the mandate are likely to succeed on the merit for a multitude of reasons. They are: we begin by stating the obvious. The Occupational Safety and Health Act, which created OSHA, meaning the founding document of this agency, was enacted by Congress to assure Americans, quote-unquote, safe and healthful working conditions and to preserve our human resource. And this is their motto, this is their intent. Like you do a declaration of trust and you have an intent, whether you clearly state it or you put it somewhere in the body. And that is in 29 U.S.C. 651, which is a statement of finding and declaration of purpose and policy. It was not, and likely could not be, under the Commerce Clause. And they're reminding you, this is all commerce here. We don't care about how you feel. We don't care about your health, even though the term health is used within the name of the entity. But it's all still commerce. It was not and likely could not be, under the Commerce Clause and non-delegation doctrine. If you go down to the 8th here, it tells you the non-delegation doctrine constraints, meaning it limits Congress's ability to delegate its legislative authority to executive agencies, aka separation of powers. Intended to authorize a workplace safety administration in the deep recess of the federal bureaucracy to make sweeping pronouncements on matters of public health affecting every member of society in the profoundest way. Meaning what OSHA is trying to do can only be granted by Congress, in so many words. And OSHA can't do it under the pretense of safety or healthful working conditions. The reason why separation of power is an issue here, or the reason why it's even brought up, is because remember, OSHA is an agency of the United States. The reason why they're staying it and agreeing that, look, screw all that stuff about making people take the jab. By the way, if you don't know, this is a tool that you can use and simply show your employee. Don't ramble on about anything. Just put an affidavit and show them this. But we'll go over how to actually use this with that, because some employers, they know there are many fish out there. There are many fish that will bite the bait. They know most employees are replaceable. And they couldn't care unless to let go of one or the other. If you care enough about yourself or the future of this nation that you're in, you take some steps that will make the difference without jeopardizing your own security financially if you're still an employee. On the dubious assumption that the mandate does pass constitutional muster, meaning let's just say that OSHA's emergency mandate about the mask, the jab, is constitutional, hence the word dubious assumption, which we need not decide today. It is nonetheless fatally flawed on its own terms. What you have to understand as to why they're saying taking the jab, wearing a face mask, or taking a weekly test is flawed. It's not, again, I want to emphasize this. It's not because they care about the everyday man. It's because it digs in their pocket and it strips power away from them. If they allow OSHA to do this, Congress will lose power. That's why they brought up the non-delegation doctrine. Where is it? Right here. Non-delegation doctrine. And we cannot delegate our authority that the Constitution has granted us to an inferior agency. Yet we have control to regulate, because the legislature makes the law that OSHA is also bound by. And what OSHA is trying to do, if they get away with it, it's kind of like executive orders. Executive orders are not legislation. Executive orders that's being passed in each state only applies to the executive department when it comes to these mask mandate. It's that simple. It's not law. It's not legislature. And that is what Congress is talking about here. If we let OSHA do this to all the employees that they're supposed to regulate based on health and safety, which is spoken of in the act that basically enacted and gave rise to that entity itself called OSHA. If we allow them to do this, then it's a law that they're creating, and we cannot let them do this. It surpasses their power. Now they're doing the same thing that we're supposed to be doing as the legislature, aka the Congress. So this is about who has the biggest balls. That's what's going on here, and you can put that to use. It is nonetheless fatally flawed on its own terms. Indeed, the mandates strained prescriptions combine to make it the rare government pronouncement that it is both over-inclusive, meaning that applying to employees and employees in virtually all industries and workplaces in America, with little attempt to account for the obvious difference between the risk facing, say, a security guard on a lonely night shift and a meat packer working shoulder to shoulder in a cramped warehouse. See? Meaning, despite the fact that OSHA deals mainly with health and hazard, they're trying to do this thing whereby they're compelling people to wear a face mask. What about a security guard working in a night place? Somebody might harm them, and we don't know we won't know who they are. Heck, somebody might rob a bank. Do you know now is the only time ever in history in North America that people can actually wear face masks into banks? Do you know that? Do you know how many tens of thousands of people with certain types of minds out there that have done certain things or are contemplating to do certain things solely based on that alone? And believe it or not, the Congress is bringing that up within this appeal. The court is bringing that up within this appeal case. And they're saying the mandate strained prescriptions. It combined to make it the rare government pronouncement that is both over-inclusive. And it covers way too much of everyone's life when it comes to commerce. Applying to employers and employees in virtually all industries and workplace in America, with little attempt to account for the obvious differences between the risks facing, meaning, for instance, a security guard on a lonely night shift. Then they gave another example, a meat packer working site shoulder to shoulder in a cramped warehouse. How are they going to be able to breathe with all that blood and gut? And under-inclusive, purporting to save employees with 99 or more co-workers from great, quote-unquote, grave danger in the workplace, while making no attempt to shield employee with 98 or fewer co-workers from the very same threat. Listen, this is the appeals court giving you this jewel right here. This is to any other places that's trying to compel anyone to wear a face mask. This is an appeal court decision right here. Most of those people who are telling you wear the face mask, they don't even know about OSHA at all. They just hear the news, they go based on fear. The mandate's stated impetus, a purported emergency that the entire globe has now endured for nearly 2 years. This is the appeals court of the United States saying, look, you're full of crap. Saying that this, if you don't wear the face mask or take the jab or take the shot or take the test every 2 weeks, it's an emergency, so you have to do it. This is the appeals court basically, excuse my language, but basically shitting on the whole thing that everybody has been hyped about this whole time, and which OSHA itself spent nearly 2 months responding to, is unavailing as well, meaning none of that stands. And its promulgation grossly exceeds OSHA's statutory authority. They're basically talking down on it because of authority purpose. They have no power to do these things. What if it's so simple? I guess it takes an appeal decision to make that clear. And even then, there are still millions of people in North America who don't know about this and couldn't care about this. If you care about your well-being and the future of your children in this nation, then this is a tool for you to use. This is an official and admissible document, an appeal court case that is of recent. After the president voices displeasure with the country's vax rate in September, the administration pored over the U.S. code in search for authority or a workaround for imposing a national vax mandate. The vehicle that landed on was the OSHA ETS, the emergency crap, like the state does. It's all an emergency thing. We went over that on one of the first few videos. The statute empowering OSHA allows OSHA to bypass typical notice and comment proceedings for 6 months by providing for an emergency temporary standard, ETS, to take immediate effect upon publication in the Federal Registry. This is the same thing that each state are doing. When you look at the emergency orders being issued by each state, it only lasts for a couple of months. And then they just keep renewing it, and when they renew it, they amend it and add some more. Some states have lifted it, which we'll go over also. If it determines A, that employees, remember this is dealing with employees in workplace, that employees are exposed to grave danger from exposure to substances or agent determined to be toxic or physically harmful or from new hazard, and B, that such emergency standard is necessary to protect employee from such danger. And the reference is in 29 U.S.C. 655 C1. As the name suggests, emergency temporary standard are an unusual response to exceptional circumstances. A lot of people think this whole C-19 thing is an exceptional circumstance. The only thing that makes an emergency is the trash people are being fed in the news. If you turn off the news and you just go by living your daily life, if the everyday man did that, everything is normal. It really is. Whatever that applies as though it's not normal out there is based on the influence of people that are feeding others trash through social media. Mass hypnosis. Thus, courts have uniformly observed that OSHA's authority to establish emergency temporary standard under 655C, which is take the jab or take weekly test and wear face mask at workplace. This is to all you people who work and they want you to either take the jab or take weekly tests and wear mask. This is your solution right here. It's right here. If your employer fires you because of that, you have money waiting for you, because this right here is undisputable. If you can prove that from the moment whereby you show them this, and then you're showing them the fact that it's unlawful and it's not enforceable, and because of that they jeopardize your liberty, pursuit of happiness, security of papers, persons, in effect by firing you, there's money right there for you. This is fresh right here. This is last month. The standard under subsection 655C is an extraordinary power that is to be delicately exercised in only certain limited situations. But the mandate at issue here is anything but a delicate exercise of this, quote, extraordinary power. Quite the opposite, rather, than a delicately handled scalpel. The mandate is a one-size-fits-all sledgehammer that makes hardly any attempt to account for differences in workplace and workers that have more than a little hearing on workers' varying degree of susceptibility to the supposedly grave danger the mandate purports to address. Meaning, in other words, it's bullshit. Thus, as subsection 655C1 plainly provides, to be lawfully enacted, in order for them to do the emergency crap, an ETS by OSHA, an ETS must address substance or agent determined to be toxic or physically harmful, or new hazard in the workplace. 2. Show that workers are exposed to such substance, agents, or new hazards in the workplace. 3. Show that said exposure places workers in grave danger, and, meaning inclusive, not or, all of it must be applied, and be necessary to alleviate employees' exposure to gravely dangerous hazards in the workplace. As we have noted in the past, the precision of the standard makes it a difficult one to meet. I'll give you a reference as to why. Observing that OSHA emergency standard authority requires determination of danger from exposure to harmful substance, not just the danger of exposure, and not exposure to just a danger, which is what everybody's afraid of. The danger is the C19. The danger is the exposure to C19. But at workplace, they are required to determine that the danger itself is based on a specific harmful substance. Tell me, since this whole C9 thing has popped off last year, about February, March, all they're just yelling is the name itself. Have they really given you a specific substance as to why that terminology C19 is doing what it does? No. But common sense will tell you, if you put on that face mask, if you get that shot, if you get those weekly quote unquote tests, there are very specific things that will happen to you. The most basic thing is suffocation. Breathing in your own waste that your lungs have filtered. Your body's a machine. Those lungs, your nose, your mouth are like exhaust pipes. All those carbon coming out. If you've ever worked with any type of automobile or any type of machinery, if you know if carbon builds up too much in that car, it's going to affect the fuel intake. It's going to affect how the car runs. And at some point, the engine will not work. And if the engine is still working because it's somehow built right, then something else is going to be affected. And at some point, its ability to use air in and out, because the car uses air pressure and all that, will be affected. And everything else will slowly begin to shut down. The flow to the brain, the lymphatic system, your nervous system, all that. Common sense. You try it. Walk around a day with face masks and just do your everyday activity. Go run out there with a mask. Do housework around with face mask. Don't take it off. Just keep it on all day. And just compare your health with how you were once before. And then you have somebody sticking some substance up close to your brain. You know that hole in your nose connects to your brain? You don't even know what's on that thing. And then sometimes the mucous membrane in your nose is probably dry. So what are they really getting to test? And then when they put the jab in you, we all know vaccines are basically the introduction of virus in your system. Then you have, once you take the first one, they tell you, oh, that's not enough, take some more. Right? And they're basically saying, and that's right there is if the stuff that they're saying you have to do to free yourself from some supposed harmful danger, whatever it is. But on the other hand, they haven't really identified that thing itself that makes up the C19. You can identify the dangers in what they're saying is supposed to prevent it. That prevention itself is the danger. But that danger itself is not identified. And that is what the appeals court is pointing out. Not just a danger of exposure, and not just exposure to a danger, but to grave danger. Meaning it really has to be an emergency. This thing only looks like an emergency because the everyday man and woman are the ones enslaving themselves. They are the ones making it work. They are the ones doing it. There's no law that's mandating anyone to do any of these things, state or federal. But you will hear people say, oh, it's federal law, it's state law. No, it's not. That shows the ignorance of the general public. And that is a problem. And not the necessity of just a temporary standard, but that an emergency standard is necessary. In its brief, Texas made a compelling argument that 655C1's neighboring phrases, substances or agents in toxic or physically harmful place, an airborne virus beyond the purview of the OSHA ETS in the first place. Meaning, the terminology within the act that created OSHA, which gave them the power and defined their power, lets you know that the terminology substance or agent has nothing to do with airborne viruses. And that airborne viruses is beyond their power. To avoid, quote, giving unintended breath to the act of Congress, courts rely on the principle of nocitur associis. Nocitur is a Latin word for knowledge. Associis means society, which basically, as used in the legal world, is just the standard used to Basically, it's like a doctrine that's used to break down ambiguous terminologies of laws. A word is known by the company it keeps. Yates versus United States. Here, OSHA's attempt to shoehorn an airborne virus that is both widely present in society, meaning they're not disputing whether it exists or not, and thus not particularly to any workspace, meaning OSHA's power has nothing to do with society. It just has to do with specific people that they're contracting with. Now they're trying to take that thing in society at large and try to say, well, we have power to make a determination that, and because of that, we are limiting you here in these workspaces to do one thing or the other. Meaning whatever OSHA can do has to be fixed and limited and must have its origin in a workspace and nothing outside of it. Otherwise, what OSHA will be doing will be no different than the power that Congress has. And non-life threatening to a vast majority of employees into a neighboring phrase connoting toxicity and poisonousness is yet another transparent stretch, meaning they're stretching their power. Other cases involving OSHA, though not ETS per se, shed further light on the intended meaning of these terms, and then they list it. They then expose the rest. It's very important to see. Basically, they go in deep details on all the problems of why OSHA cannot, or your employers cannot compel you to take the jab, otherwise you'll be fired. Put this to use. If we were to go over this in detail, it's going to take hours. There's no need to take all that time. The majority of stuff is right there. This is U.S. Supreme Court. And here's the conclusion. Health agencies do not make housing policy. And occupational safety administrations do not make health policies. It's outside of OSHA's jurisdiction to try to use something supposedly going on within the public at large to limit certain people from being able to work. In seeking to do so here, OSHA runs afoul of the statute from which it draws its power and likely violates the constitutional structure that safeguards our collective liberty. For these reasons, the petitioner's motion for a stay pending review is granted. Enforcement of the Occupational Safety and Health Administration's C-19 Vax and Testing Emergency Temporary Standard. This is the title that they will have given to your employer as notice that will shake your employer up. And then that's just the title. Underneath that title will have conditions that will fine you if you don't do this. If you don't fire your employees or compel them to take the shots, and if they don't want to take the shots, they have to take weekly tests and wear face masks. This is it right here. If your employer is not giving you this notice when they're telling you to do one thing or the other without the, regarding C-19, they're not putting you on notice properly. But now you know. And now you know that it's been ruled unconstitutional. Remains stayed, meaning they've stopped it, pending adequate judicial review of the petitioner's underlying motion for permanent injunction. Meaning they're still thinking, okay, should we make this permanent or not? In addition, it is further ordered that OSHA take no step to implement or enforce the mandate until further court date, meaning it is not enforceable. Meaning the court, as of now, they have temporarily said, you know what, stop all that mandate. An order from the United States Appeals Court tells OSHA, which your employer is listening to when it comes to the jab and the face mask and all that, take no step to implement or enforce the mandate that your employers are being threatened they will be fined unless they tell you to take the jab or do a weekly test and wear face masks until further court date. That further court date is going to determine whether this state on that mandate is going to be permanent. So this is still standing right now because they're still making a decision as they've determined that they're going to stay it. They're going to stop it. But what they're determining is, are we going to make it permanent or not? This is as of last month. So you put this into consideration. And if you want to know how to put it to use with some other affidavit that you write along and send to the human resource and all that, holler at me. I can assist you with that. But if you can do it yourself, do it. Do it. Speak up. It makes all the difference. If you're not speaking up, you are going against the stuff that the Supreme Court, the Court of Appeal is saying you have the right to do. It's right there. Here's a signed order right here. If only you knew how admissible this is. Right there. Right there. Look at this. This is an order that your employers are bound by. That OSHA, who is putting your employers under the gun, are bound by. The appeals court just shut them down. They're saying while we're shutting you down doing that, we're going to consider whether it's going to be permanent. Texas, who was one of the petitioners in the appeals case that was decided last month and is still being considered whether it's going to be for good, was one of the petitioners, and they themselves passed an order in their state saying screw all this crap. October, 2 months ago, 4:30 p.m. filed in the Secretary of State. This is admissible evidence right here. Pursuant to his powers as governor of the state of Texas, he has issued the following: Executive Order Number GA-40 relating to prohibiting vax mandates subject to legislative actions. Meaning unless it's made into law, these mandates are prohibited. So if you're at Texas, this paired up with the United States Appeal Court order is to your favor. And guess what? There are other states with this exact verbiage. If not exact verbiage, then similar verbiage. There are many states. Many states. It's right there. These things are happening right in front of you. But if one is stuck watching TV, listening to more crap that you're being fed in suggestive videos and YouTube feed, you're going to be stuck in a world under a box when all this is going on around you. Use the solution that is blatantly being given to you. It is fresh. Hey, just a quick reminder. Don't forget to check out the Patreon page. There you'll find documents that been used personally successfully and other deeper details on how to actually use these things beyond what they are, who's involved, and why. Only so much can be said on YouTube platform, and a lot more details and things people are seeking and they can't find, or things they seek and are not too sure about. And if you yourself have any specific questions or any specific topics that you want to hear about, learn about, then the Patreon page is the place. You can directly message me and let me know, and if I know about it, I'll be more than happy to share it with you. If I've done it before, I'll be even more than happy to share it with you. All right, take care.